purpose is to review the legality of the applicant's arrest, imprisonment, and detention, and challenge the authority of the prisoner or jail warden to continue holding the applicant. The application is used when a person is held without charges or is denied due process.
Okay, can we stop here, counsel?
Yes.
How did they end up in prison in the first instance?
My Lord, that is for the Attorney General and the Commissioner of Prisons to explain by way of evidence.
So for you, you have no idea.
My Lord, I will explain.
Yes.
My Lord, initially there were charges that had been preferred against them as explained in the affidavit of Winnie Lyanyima and Proscovia Konihira. My Lord, that is well explained. If I may go there, my Lord, to read the relevant paragraph.
What is the explanation?
The explanation is that, my Lord, the defunct General Court Martial had preferred the charges against them. And on the 31st day of January, my Lord, this year 2025, the Supreme Court unequivocally pronounced itself on the constitutional.
Remove the handcuffs. Remove the handcuffs. Remove the handcuffs.
Freedom for Aaron! Aaron, the conqueror of the court martial!
Were quashed by the Constitutional Court, and my Lord, the decree to that effect was extracted.
Do you have it?
My Lord, I'm sure it's on record, my Lord.
But do you have it? Take us step by step.
Yes, my Lord, we can, if I may be granted more time from the 10 minutes I had earlier requested for, because I thought court had addressed itself with these matters.
But you see, we have members of the media, and this is very important for them to hear what the Supreme Court said.
My Lord, it is hereby ordered that
Number one,
the declaration of the Constitutional Court that Section 119, subsection 1G, now Section 117 of the UPDF Act, which provides that any person not otherwise subject to military law, who aids or abets a person subject to military law in the commission of a service offense, is unconstitutional, so that order is hereby set aside.
now in one line, take us in one line, what is that paragraph state for our media?
My Lord, initially the Constitutional Court had held that Section 119, which is now 117, that had provided for a situation where civilians would be subject to military law if they abetted the commission of an offense by a serving officer, that was a valid law. They had not nullified those provisions. Now, that order of the Constitutional Court was set aside by the Supreme Court, meaning that Section 117 has now been nullified by the Constitutional Court. All charges, all ongoing criminal trials, all pending trials, before the courts martial involving civilians must immediately cease and be transferred to the ordinary courts of law with the competent jurisdiction. 3.
Okay. Mina. Mina. Ogwa bulugulwa.
Ogwa green kuliwa ane no ogwa green.
Gali wangu. Aha. Tulikiria eh? Basi. Checho nuwaru. Naye kwa gade nyo. Aha. Kama ngera mbudiyo. Wa kamera ruwanja. Wa kamera. Yes. Okay. Tulikiria. Tugene mbasha para baje. Yes.
With due respect to the trial judge, we do leave the court premises today with the disillusion in the way the matter has been handled. We are in a disillusion in the way the whole matter has been processed, because the writ of habeas corpus, which in simple terms is a prerogative order which can only be given by court in exceptional circumstances like this, where one's liberty has been curtailed without any justifiable or lawful cause. It's a matter which has to be disposed of expeditiously. And when you look at the provisions of Article 23, read it together with Article 44, this right to habeas corpus is non-derogable. It comes into play in emergency situations like this, where one's liberty is curtailed and their life is in danger. So Dr. Besigye was brought together with Obed Mutale this morning under very unreasonable circumstances. There was an order that he be returned to Zira without a valid remand warrant. Yes, we appreciate that court ought to have listened to all of us, both sides, before rendering a decision. But we made a good case for quick intervention, and we thought court would come up with the declaratory orders today about the legality of the doctor's incarceration or the curtailment of his liberty. Unfortunately, it has not happened. Yes, we have made our submissions. We are grateful that the judge has listened to us, and we also appreciate the fact that he interrogated the circumstances under which Dr. Besigye and other prisoners of conscience has been detained in total violation of the Supreme Court order or directive. Unfortunately, we have not got a decision today. We are walking away from the court premises without agreement today. So we expected a decision to be delivered today. It should be instant. And we brought out all the relevant authorities. That would require that, honestly speaking, the justice of the case required that today there should be a remedy, there should be a decision, and it should be instant. Unfortunately, that is not the case. And to make matters worse, we have not been given any idea or clue as to when the decision will be given. We have been directed that tomorrow we write to the judge requesting for the date when the decision will be delivered. It's really baffling, because at least if he was not in position to give the judgment today, probably would have indicated that give me today or tomorrow, then I'll deliver the ruling within the course of tomorrow or the day after tomorrow. that was never to be the case. You see, you cannot again curtail one's liberty, which are duly guaranteed under the Constitution, the Bill of Rights, on account of the government red tape bureaucracy. You had their flimsy arguments. The state, the Attorney General, they are saying they are exchanging the communications, a letter to the principal judge, a letter to the Chief Justice, a letter to the CDF, a letter to the Attorney General, a letter to the DPP. They are just still exchanging the communication. They are hiding under red tape, under bureaucracy, to continue violating the rights of Dr. Besigye and other prisoners of conscience. We thought court would bring that to a halt, that would stop that kind of impunity. Unfortunately, it would appear court developed fit of delay and had to delay the delivery of the judgment. So we are going to retreat and see the next course of action, how we shall get under the circumstances as we await for the court decision in this matter. But we leave these premises with a heavy heart, with disillusionment, and of course devastation. That is it.
Honorable, the most concerning thing has been doctors' health.
I've canvassed all that, because you have really stated the fact that Dr. Besigye, the judge ought to have recognized that fact, and it should be a compelling reason for the court to deliver the judgment today, to determine the fate of Dr. Besigye today. And we thought that would be instant, given the deteriorating health situation of Dr. Kizza Besigye. So we thought that would be a significant matter that would compel the trial judge to render a decision today. So I think that is the matter we have canvassed sufficient. So or any lawful order given by court for the authorities in Luzira to keep them in custody. My Lord, the affidavits which are